Welcome, everyone. Can you just go back to the agenda? Thank you. I just wanted to show the order of events that we are going to go through in this evening's program. We've had the housekeeping, the media release. You're about to enter into our opening remarks. We will have our program, and we'll introduce the speaker. The speaker will present his program, and then we will get into the raffle that Lois just talked about. We'll share some resources. We're going to ask you to do a survey, and then we will have closing remarks. Welcome and good evening, everyone. I'm Jackie Robinson, and I and Alika Muhammad are the co-chairs of the Economic Development Committee of Central Jersey Alumni Chapter of Delta Sigma Theta Sorority Incorporated. We thank you for joining us for this latest installment of the Generations to Generations Legacy Building series. Generations to Generations was developed by Central Jersey Alumni Chapter to provide information, tools, and resources to increase generational wealth in our communities. There's research out there that shows that the wealth of the average white family is 8 times that of the average Black family. Statistics also show that 30% of white families receive an inheritance compared to only 10% of Black families. And the amount of the inheritance that white families experience is doubled for that of Black families. You can see how this is a perpetual cycle. Creating and retaining less wealth means less wealth to pass on, which makes it more difficult for our next generation to create and retain wealth, and on and on and on. Your presence here tonight is proof that we know it is our responsibility to break this cycle, and we can if we have knowledge and a plan. In this series, and we hope to have 2 additional events by the end of our program year in June of 2024, we expect to cover strategies to build wealth, manage wealth, preserve wealth, and transfer wealth. Future events may cover topics like paths to home ownership, starting a business, financial planning, and investing. Tonight, we're focusing on the preserving and transfer of wealth through estate and elder care planning. We'll get started in just a few minutes, but first I'd like to introduce Patricia Williamson, the president of Central Jersey Alumni Chapter of Delta Sigma Theta Sorority Incorporated.
Thank you, Soror Robinson. Good evening, ladies and gentlemen, sorors and guests. I hope you are well and having a good day. Central Jersey Alumni Chapter is a group of dynamic women bonded by sisterhood, committed to community uplift and engagement in the Black community through public service, scholarship, and social action in Union, Middlesex, and Somerset counties. Chartered by 30 remarkable women in 1975, with a common love of service and need to contribute to the community, CJA has grown to over 400 women. Tonight's Generation to Generation Legacy Building program is hosted by our amazing Economic Development Committee. Economic development is the first point of Delta's 5-point programmatic thrust, which guides the service of Delta Sigma Theta Sorority Incorporated across the globe. Here in CJA, we have committed to bringing our community closer and closer to financial freedom using tools and techniques through our Generation to Generation series. Tonight, we're going to learn how to prepare financially for the future and preserve our assets to both care for ourselves as well as pass along to our loved ones. Let's put on our proverbial oxygen masks on first, then we can assist others. I want to thank our economic development co-chairs, Jacqueline Robinson and Alika Muhammad, for their leadership and the entire committee for planning and delivering this informative and interesting program to you. Many thanks to Attorney James Carthy for taking time to talk to us about legacy building. Thank you so much and have a great evening.
We're now just going to have a few questions to ask you in a poll just to see where we all are in this thinking about planning for legacy building.
A few more seconds. I am ending the poll. The poll results. The first question asks, have you ever personally benefited from an inheritance? 56% of our respondents said yes, 44% said no. The second question, if yes, did you receive proceeds from a life insurance policy? 31% said yes. Money, stocks, or bonds. 23% said yes. I need to see them. Other monetizable or income generating assets, real estate, and a business interest. 46% said yes. Do you have a plan to build and protect and transfer your wealth? 51% of the respondents said yes, 18% said no, and 31% said they were thinking about it but don't know what to do or how to get started.
Thank you, LaQuanda.
You're welcome.
Okay. Well, our survey shows that one, we're above average for the demographics of most Black families, and that's a good thing, but it also shows that we are about maybe roughly half of us have ever received an inheritance, and it spans between life insurance policies, money, stocks, and bonds, and other monetizable income. And that roughly half of us have a plan, but there's 31% of us that don't have a plan. We're thinking about it. We need more information. 31% needing more information, 18 that just don't have a plan at all. So we're grateful for our speaker tonight because he's going to help us and move us along here. Our speaker tonight is attorney James Carty III, and he is the founder of the James E. Carty III Professional Corporation, a law firm located in Piscataway. He is a Harvard Law School graduate, and he also graduated cum laude from Harvard College with a Bachelor of Arts degree in Government and African American Studies. Mr. Carty is licensed to practice law in New York, New Jersey, Washington, D.C., and Texas, and he's a member, which is really important to us, of the Elder and Disability Law section of the New Jersey State Bar Association. In addition to assisting individuals with estate planning, wills and trusts, elder law, Medicaid planning, and asset protection. His firm can also assist with probate litigation. Emphasizing his commitment to legacy building in our community, his firm's tagline is "The community's lawyers, protecting you, your business, and your estate." Living in this motto, he has presented many seminars in New Jersey and New York on elder law and estate planning to church, government, community groups, and professional organizations. And we are so happy that we are now included in those organizations that benefit from his knowledge and expertise. In speaking with Mr. Carty while planning this event, he said we have to create a culture of planning. And he's here to get us started on building that culture of planning. The website for Mr. Carty's firm is www.cartylaw.com. When you go there, you'll see that the team of attorneys at his firm offer a full range of personal, business, and estate legal services, many of which you may need as you begin to actualize your generation to generation legacy building plan. Mr. Carty has also provided a handout that's going to summarize his presentation, and we're going to drop a link to that presentation in the chat. I do want to remind everyone that we're using the chat for questions. So as we open the chat up, please reserve that use for questions as opposed to general comments, so that our team can keep up with the questions and make sure that we're feeding them to Mr. Carty appropriately. And with that, I'm going to turn it over to Mr. Carty to begin sharing this wonderful information with us.
Well, thank you for that introduction, and I want to thank you for inviting me to speak with you tonight about estate planning. This is a very important topic, a topic which really touches every person and every family. And it touches every person and every family because all of us are going to face the life transition of death at some point. And most of us, if we are blessed to live long enough, will suffer through the life transition of a disability. So that is why it's something that you cannot ignore if you're really talking about addressing the whole issue of generational wealth. And I applaud you and your organization for the focus that you have. It's so much needed in the community, and I'll do my very best to give as much information tonight as I can. I cannot give legal advice, but what I can do is I can address your questions as hypotheticals and give you information. And so if you do have questions, as was pointed out, please put them in the chat. I will periodically stop and solicit those questions and try to address them. And I understand there will also be a question and answer session at the end. So let's talk about estate planning and what it is. It is a process which I like to kind of anchor it in the whole concept of Sankofa. Okay, looking back so you can move forward in a positive way. And that's really what we do. We look back at the relationship blessings and the material blessings that we're going to be leaving behind so that we can move forward with confidence without the anxiety of not knowing what's going to happen to our family, our loved ones, and can we really pass on that inheritance that we want to. And when you think about estate planning and its purpose, it's really being a good steward of those material blessings you've acquired during your life and being a good steward of the relationship blessings. And I want to make this point because a lot of estate planners just focus on the material blessings without any, I don't say without any, but without, I think, appropriate focus on the relationship blessings. And you have to really look at the interrelationship between the two. Because in my practice, not only do I help people with planning, but I also represent people in litigation. And the relationships in families that are torn apart when a death occurs or when a death or illness occurs, costs the family money as well. The two are interconnected. The more cohesive the family, the more orderly the family proceeds through these storms of death or disability, the more wealth the family will have, and the more wealth the family will have to pass on. So estate planning is something that does promote economic development at the family level. And it also promotes self-determination at the family level. And what I mean by that is estate planning can be looked at as a form of private family self-governance. And what do I mean by self-governance? Well, deciding what's going to happen to you if you get sick, or to an elder who is sick, deciding what family resources are going to be spent and how, who they will be passed on to, that whole process is a governance process. Just as your organization has bylaws and has structure and has a budget and you have a form of governance, each of our families need to emulate that to a certain extent. We need to govern ourselves, our families, so that we can protect and maintain the resources that people have worked so hard for throughout their lives, which I see squandered. And how do I see it squandered? I see it squandered many times. Even people who are well advised and have done all the basic documents, I see it squandered because they have not taken into account the cost of long-term care or nursing home cost, that they intended to leave an inheritance, but it's really diminished or eliminated because it's all used in the cost of care that could have been paid for maybe by Medicaid or another source. I see it squandered when people fight in court, guardianship fights. Who's going to be the guardian who will be in control of mom or dad? Well, that's a family governance issue. A family governance issue that has tremendous amount of emotion attached to it and has devastating financial consequences and devastating consequences to the relationships of those family members who are on the opposite sides of a court battle. I've never known anyone to come out of a litigation really liking the person they litigated against better. It just doesn't work that way. So it's really not something you want to put your family through, because these are relationships which, if we're blessed to have family members that we're leaving behind, these are relationships which no one has ever come into my office and said, well, when I pass on, I want all of my family members just fighting with each other, never talking to each other again. Now, obviously, that's the extreme, but that is not what most people want. Unfortunately, too many times it happens because we don't look at having a system of family governance in place. And so therefore we squander the resources. And when you talk about litigation, whenever family fights, it's like a civil war. The cost of a civil war, both sides pay. Each family member is paying. So no matter who wins, the family loses. That's the bottom line. So to the extent we can minimize that type of conflict, manage that type of conflict, we can reduce the loss of family resources when the family goes through a disability or a death. I also see people making tax mistakes. And I'll give one, which really squanders family resources. One simple tax mistake, which I'm going to put out there, is there is something called the New Jersey inheritance tax. This is a tax based not on how much necessarily you leave as an estate, but it's really focused on who you leave it to. And one way to get around New Jersey inheritance tax is by using life insurance. I saw on the survey that a number of people were beneficiaries of life insurance. So let me just talk about this for 1 minute. If I want to leave $100,000 to a niece or nephew that maybe I raised as my own child, and I leave that to them in my will through the normal probate process. Or I have a choice of leaving that to them as a beneficiary of a life insurance policy. The difference between which choice I make, which will be based on my awareness of this rule, on that $100,000 could be $15,000. Because a niece and nephew's inheritance, that is, they're going to be taxed on New Jersey inheritance tax probably at about a 15% tax rate. So instead of them getting 100,000, they'll get 85,000. Now, if instead I made them the beneficiary of that life insurance policy and didn't leave them anything in my will, they would get $100,000 because that life insurance policy beneficiaries are exempt from New Jersey inheritance tax. That's one rule. Knowledge of that one rule could avoid a $15,000 mistake for that family. Now let's imagine that there are 1,000 families in the community that make that mistake. Let's say within New Jersey, 1,000 families. What's 1,000 times 15,000? $15 million. And let's say this mistake is made over and over again, year to year. Let's say this mistake is made over a 10-year period. How much money is that that's left the families in the community? $150 million. So I just do that to illustrate the tremendous amount of wealth that we lose because we are not aware of all the rules and we haven't planned appropriately for them. I'm not saying every family is going to make that particular mistake and going to lose that 15,000, but I can tell you I know lots of families that have lost money in addition to making that mistake through litigation, and they many times lose way more than 15,000. I know families that have lost tens of thousands, unfortunately hundreds of thousands of dollars in litigation. So if you take these losses and then extrapolate that throughout the community, you are talking about a tremendous wealth, I want to say loss of wealth. And if we could just stop that loss of wealth, there would be tremendous things that could be done from an economic development point of view. What could those families do with $15 million? What could your organization do with $15 million? What could your church do with $15 million? How many businesses would that fund? How many people could go to college with that money? How many student loans would be paid off? A lot. And what's the impact on the community and the economic development of the community? It could be tremendous. So I'm saying this because I truly want to motivate you to think about estate planning, not in the way it's traditionally thought of. Most people think of estate planning as it's one of those things I know I should do, really don't want to talk about it because it's unpleasant. We're talking about death. We're talking about people getting sick. We're talking about family relationships, which are fraught with all types of emotions. But, it creates many times for people this anxiety and they avoid it. I want to motivate you to think about it as a different way, to think about it as a tool of liberation, a tool of economic empowerment for families, and a tool of self-governance and self-determination for families. Because what's the alternative? If you don't make a plan to govern what's going to happen to you, your family members, and the wealth that you've acquired or they've acquired, then your family and you will be exposed many times to the chaos of external forces, which will cause a lot more conflict than is necessary. And if you think of just the whole court process, as I said, is adversarial. And lawyers tend to be competitive people. They're trained to be competitive, okay? So not all lawyers are crazy, okay? But I've come across quite a few competitive lawyers that like to win. But when we talk about our families, as I said before, there is no winning for many of these conflicts. I represented, give you an example, I represented a sister against her brother in a guardianship matter. And their father, they were fighting over, was very ill, was towards the end of his life, but he was very ill, and there was a decision as to where would he be cared for and who would care for him. Would he be cared for in New Jersey under one family member's authority, or would he be cared for out of state? They went into a court battle in which lots of money was spent, and even worse, the relationships. I cannot tell you the effect of the relationships. In the courtroom, the elder, the father, was wheeled in a wheelchair in front of a judge, and on one side of the courtroom sits one side of the family. On the other side of the courtroom sits the other side of the family. And during this trial, we had a trial, and during this trial, family members are saying the worst things that they can say about each other to try to convince this judge that the family member, the other family members should not be in charge. And I can tell you, family members know how to hurt people in their family better than anyone else. They know what to say. And at one point during this trial, one lady actually picked up her child, put her hands over his ears, and ran out of the courtroom so he would not have to hear what these family members were saying about each other. I guarantee you that when that elder sat down and thought about what's going to happen in my later years, he never imagined that he and his family would be going through that. And I don't say that just to scare people. I say it to say it's very important that we face these issues calmly, purposefully, during a time when we're not in the middle of the storm. Because when you're in the middle of a storm like that, the ability of family members to reason, to compromise, to cooperate is diminished. That ability is greater now when you're sitting down with an advisor and you're sitting down with family members and having these discussions ahead of time. So that is really kind of, I just my philosophical take on estate planning. I hope you'll share that that it is something that not only needs to be done, but is a way that we can move the needle forward on economic development and self-determination. And what is that? Well, that we're talking about is really liberation. So I do think it's important, but from the big picture to now go down to some of the more granular things of what is estate planning, what are the tools. So let's talk about today some essential estate planning tools. We'll talk about long-term care planning, because that is the one thing that I often find there are so many questions about, and it is such a big risk that is not taken into account. We'll talk about business succession planning, because most family businesses do not survive the death or disability of the founder. And that right there is a tremendous loss of wealth, because I've seen people work their whole life, build a business, get sick or die, and all that goodwill evaporates. And because they're not there to operate that business, there's no economic value that's passed on to the next generation. So we can't ignore that for those of you that have a business or that intend to have a business. If you're talking about economic development, you've got to talk about business succession planning. And then, as I said, we'll talk briefly on a few tax issues. So let me introduce kind of the essential estate planning documents. if there's nothing else that person does, they should at least have these basic documents in place. First is a will, which is a document in which you appoint someone to administer your estate, that's the executor, and you say where you want your property to go, who's going to inherit from you. And if you have minor children, this is key, you get a chance to say who you want to be the guardian of those children. Because if you die, and let's say you and your spouse are both gone, what household will your children be raised in? Will they be raised together? You can have a say in that. If in your will you choose a guardian for your children, is not 100% sure that a court's going to accept your choice, but many times a court will give great deference to the choice of a parent over a situation where one side of the family lines up and says, this child should come with us, and the other side lines up and says, no, this child should be with us. You don't want your children in the middle of that. You don't want your family in the middle of that. And you're deciding what type of household your family, your children will be raised in. Well, if you're not there to raise them, wouldn't you want to say in the type of household, the values that you have, maybe you emphasize certain things that you want your children to emphasize in their value system? Well, that goes into the choice of the guardian. So that's a very important thing, putting money aside just if you have minor children. The other thing is, if you're leaving any funds to a minor, your will should have a trust in it, and you should pick a trustee to manage those funds. And the reason why that's real important is that if you just have, and many times, and we're going to talk about the probate estate and the non-probate estate, but many times children will inherit large sums of money. And when that occurs, that money is held by the surrogate in an account. So your family loses control. If your family members want to use that money for the minor, maybe you think that they should go to private school, they may have to convince a judge that that's an appropriate expenditure. And they don't know you, your family, your values, and what is appropriate in your family situation and what isn't. Okay. So you lose that control over that. And guess what? At the wise age of 18, the minor inherits all the money, free from any direction of anyone else in the family. They can tell everyone, I don't care what you say. My parent left me this. It's my money. And guess what? They'll have lots of new friends with lots of ideas on how to spend this new money. And that's not what you intended. So once again, if we have minors that we're leaving an inheritance to, we want a guardian for those minors. We want a trust with a trustee that you've selected. And in your trust, you can say when your child can take money out of the trust, regardless of what the trustee has to say. So you can say, trustee, here's someone I'm picking whose confidence I have in their judgment that they will manage this appropriately. So it's not saying that your child can't have that private school paid for them, but the trustee will make that decision as to whether the money is paid for college or is invested in crypto. So that's where you get to put that judgment in there. And then you get to say, look, I don't want my child to never make a mistake with money, because quite frankly, all of us have made mistakes in our lives, and we've made mistakes with money. And many times people will learn from those mistakes in a way that they wouldn't otherwise learn if you just told them. Okay. So given that, you may say, I want them to have the responsibility and the freedom at some point, but I don't want them to make a mistake that's going to blow everything, the entire inheritance. So maybe I'll allow them to take out a quarter of their inheritance at this age, maybe when they finish school, another quarter at another age. Or some people will do a third at different ages. So you get to look at what is appropriate for your child, and you get to pick people in the family or friends that are able to work with your child, to have a good relationship with them, and who understand what your values are. Because every family doesn't value the same thing the same, and how they would spend money may be different. So isn't it better for you to set up that system of governance as opposed to your family members having to rely on an external institution like a court to decide that for you and your family? So that's a little bit about the will and minors. Also, if you're going to leave an inheritance to an elder who may need to qualify for Medicaid to pay for their long-term care, or if you have a disabled child and you want to leave money to take care of that disabled child, and that disabled child may be receiving benefits that are means tested. I mean by that are you can't have more than a certain amount of assets or income possibly to get those benefits. Then you want to think about putting in that will a special needs trust or supplemental benefits trust, special type of trust to hold those funds so that hopefully that inheritance won't be counted against that elder or against that disabled child when it comes to their eligibility for benefits. Instead, what you want to do is create a private pot of money that is walled off from that can supplement what they would otherwise get from their benefits, but not replace their benefits. And then you would like to have control over that private pot of money, which is what you would do in your trust, and say that, well, if my child were to pass on or that elder were to pass on, then this is the other person in the family, or this is the charity, this is the sorority, the church that I would like these funds to go to if there are any left over. Because otherwise, if you don't do that, and that person is knocked off of their benefits, the inheritance will be spent on their care, and there will be nothing extra left to go to any other family member or any sorority or church or anyone else, any charity that you want. And so once again, if we're talking about wealth, generational wealth, how do we stop losing what we have? And I do think we're owed reparations, but I think we need to work on both. We need to work on keeping what we have and getting more at the same time. It's not an either or, it's both. So we talked about a will a little bit. The other advantage of having a will is that if you get to pick who the executor is, and you get to say that that person won't have to post a bond in order to qualify as your executor. Because if you die without a will, then you haven't spoken as to who's going to administer your estate. And whoever is chosen by a court, if your family cannot agree, and if we're talking just about children, they all have an equal right to administer their parents' estate. And adult children, if you thought kids could fight when they were young, just wait till they've got education and money and lawyers. They can really fight. Okay. So, if you can avoid that by saying, look, this is who I want to be in charge. It's going to be so-and-so. And if they can't, I'll have a backup person and another backup person. And maybe by way of the backup people, you will be able to make everyone feel okay. You've thought about everyone, but you're putting the best equipped people there. Okay. And so who do you choose to play that role as executor? Well, you want to choose someone who's honest and who's diligent. Okay. Those are the two characteristics for any role, whether we're talking about executor of your estate or we're talking about an agent under a general durable power of attorney to manage your financial affairs when you're disabled. Whoever we're a trustee of a trust for your kids, honesty and diligence. Those two characteristics, in my experience, far outweigh education, skill, all the others. Why? Because an honest person will try their very best to do the right thing. They will. And a diligent person will go get the help they need. If they don't know the answer, they will go find someone who does, who can help them get the answer. So just being honest is not enough, because I've seen honest people mismanage things. They didn't have the diligence. But you do need both. You need both. You really do. So that's the type of person one would pick. We talked about the will, the executor, guardian, trustee, types of trust you may want to have in the will, the advantage of not having to post a bond, which requires the person to basically go through a credit check and pay an insurance premium to ensure that they manage the estate appropriately. Okay, but you can do away with that cost and with all of that by having that will and appointing someone as executor. So I'm going to just stop briefly, because I know I've said quite a bit, and see if there are any questions that anyone wants me to address right now. If so,
Yes.
I will.
Mr.
Yes.
Carty, we have a couple of questions. So
Okay.
the first one is, does the New Jersey inheritance tax apply to children and spouses? Are there applicability thresholds based on the amount of the transfer or the amount of the estate in total?
Yes, there are. It's an excellent question. So let me just, I'll just jump right into New Jersey inheritance tax. New Jersey inheritance tax, if you want to think of who's exempt, the way I like to think of it is if you go up the line, your parent, your grandparent, you go down the line, your child, your grandchild, they're all exempt from New Jersey inheritance tax. So if you leave property to those people, zero New Jersey inheritance tax. When you go sideways, you can go to a spouse, they're exempt. But when we go beyond a spouse sideways, when we go to a brother or sister, we start to run into New Jersey inheritance tax. And if we go beyond brother and sister to cousin, niece, nephew, friend, we're running into New Jersey inheritance tax. And for siblings, there's an initial amount that's exempt. And I don't want to tell you wrong. I think it's like the first 20,000 may be exempt, and then it's taxed at a lower rate, and it's taxed at a higher rate if we're talking about someone who's a friend, someone who's a cousin, an aunt, an uncle, a niece, or a nephew. So it does depend, but if you're going just up and down the line or just to your spouse, that's totally exempt. Okay. I think that addressed that question. Was there another question in there that I didn't address, or is that?
I have a couple more questions.
Okay.
So can you address the pitfalls of a do-it-yourself estate planning, and also 1 to 2 things everyone can do regardless of their level of wealth or affluence?
Okay. Excellent questions. The pitfalls. Oh gosh. The pitfalls are this. Do it yourself. It's risky. It's not impossible. I think I'm a smart guy. I think I could sit down and learn how to maybe do an operation on my hand. If I had enough time and training, I could probably figure it out, but I may mess my hand up. And do I want to mess my hand up? What's the risk to me of messing my hand up? It could be pretty big. So that's the way I look at it. It's not, some say, oh, it's impossible, you can't do it. Oh, yes, you can. That's not the issue. The issue is what's at stake, what's the risk, and what's the level of knowledge that you need. And so, but this gets into your other question, which is, well, if I have limited resources, maybe I can't afford to get all that help, that with all that expertise. Okay. Maybe I just can't afford to do that. So does that mean I can't do anything? No, it doesn't. It means that you're going to And there are good things out there that you can do. And the do-it-yourselfs are not, they're not worthless, okay? But they don't many times address some of the big issues. Why are we doing this? We always have to come back to that. We're not just doing a document so we can check off a list and say, oh, I did that document, so I'm really good now. We're doing this for our families. We're doing this to preserve those blessings that we've gotten so we can pass on from one generation to the next. So if I do a will myself, and let's say it's not self-proving, okay, where it doesn't have an affidavit, it's not notarized, it may be valid. Maybe I do what's called a holographic will or a handwritten will, okay? Will my will count as a will? Possibly. But what is going to be required? Your family's going to need to go to court, convince a judge that, number one, this is a will. It's okay. Number two, there's the potential for a lot more conflict as to what did she really mean in that will. So what does conflict mean? Conflict means wasted wealth. That's what conflict equates to, okay? And it also equates to destroying family relationships. We don't want our family members to have to go to court. How much will it cost for our family member to hire a lawyer to go to court with our do-it-yourself will versus if we spent that money instead on getting good advice and a good document in place? I can tell you it's orders of magnitude more. If you think lawyers are expensive when it comes to doing documents, all you have to do is have the misfortune of being involved, of having to hire a lawyer to represent you in court, and you will quickly see how expensive court is. It is way more expensive. You will spend money faster and at a much higher rate. So it's really, and many times there are people that do not have the ability to hire an attorney. And there are some pro bono things that the bar associations will do to help, especially seniors, get wills done. But if it's a choice between, do I spend, some money, it could cost me thousands, okay, doing documents, or do I spend 50,000 or 100,000 in litigation that could last a couple of years out of my life and have all my family members not talking, worried about, should I talk to this person? Or what's going to happen when we get into court and all? Is that really worth that money? That is a value choice that you have to make in terms of what is family peace worth to you? What is a transition passing on, that wealth without it being lost in lawyers' fees? And the thing you have to know many times about these types of fight in this area of law, many times, and this is a little bit different than a lot of areas of law, but many times the legal fees of both sides will come out of the estate. The legal fees of both sides may come out of that elder whose guardianship you're fighting over, of both sides. So if you think how expensive one lawyer is, imagine having two lawyers, and not just two lawyers, but two lawyers fight each other. Extremely expensive. So that's the pitfalls, I would think, is that the real cost of do-it-yourself estate planning is hidden. You don't see it up front. It's like an iceberg. You're just seeing the tip. But if you hit that iceberg, that's when you really feel it, okay? There's another part of that question, which I'm not sure I answered.
What she's asked about the one or two things everyone can do regardless of their level of wealth.
Yes.
Affluence.
Regardless of your level of wealth, everyone can sit down and organize themselves and then their family and talk about what's going to happen if you get sick or if you die. or what's going to happen if mom or dad gets sick or dies. Having these discussions doesn't cost you money to have that discussion now. And I think that's one of the most valuable things, because if you have the discussion now, if you organize yourselves, you understand what moms, sometimes people don't know what the elders' affairs are. They don't know anything about. And the generation, my parents' generation, very private, extremely private about their finances. And I understand why, because, people were coming at them constantly, trying to take whatever they had. So they held on very tight. But there comes a point where the family needs to talk to the elder and say, look, if you're going to be able as the elder to lead us through this transition, which we're going to go through no matter what, all of us are going to go through it, but we want you to lead us through it and we want you to have a say in it, well then, let's have that discussion now. So have those discussions, because I've seen situations where there was a consensus amongst the family members as to what was going to happen with withdrawal of life support, end of life decisions, things of that nature. And it was a hard time, but it was beautiful to see this family come together with a consensus. And there were strong feelings, disagreements, but to resolve them in a way that, look, I don't agree with you, but that's your mother. That may be my sister. That's your mother. I'm going to let you make that decision. Okay? Because I know that's what we talked about this. That's what she would have wanted. That goes a long way to holding off. The legal documents are important, but just as important is having that conversations and consensus. So I'm saying, if you have no money whatsoever to get any legal advice whatsoever, and you can't get any legal advice, maybe you do it yourself as best you can, and you have those discussions so that the likelihood of your do-it-yourself being challenged goes down, because hopefully we're able to create consensus. But I can tell you, family consensus can be a difficult thing when you're talking about adults, their own minds. We all got free will. God gave us free will. It's a beautiful thing, but unfortunately it means good people, honest people. I got to tell you, the worst conflicts I see are not between the crooks and the honest people. They're between the honest people and honest people, because you can't get an honest person very easily to back down. How could you let mom or dad suffer? How could you kill mom or dad? These people both feel they're diametrically opposed positions, but they're coming from a very heartfelt position, and no amount of money is going to change their mind. You can't settle with them on that. That is so all I'm saying is, some people say, well, I know this is a person of good integrity. Yes, but good people can disagree on these issues. And when they do, those disagreements can be fierce. And so it's because they care. And they're not fake. Okay. Fake people will, give me a little money, I'll go away, whatever. That's what I'm really there for. I really don't care. So I know I got off a little bit, but having the conversations in the family, trying to build that family consensus, putting in place whatever you can put in place. And if all you can put in place is a do-it-yourself, then yes, do that. I got it. As I said before, it's not the best thing to do. It has its downsides, but it's better, maybe better than nothing. Okay. So I think I addressed those. Yes.
So you had talked a lot about before with the trust and leaving legacies to the children and things like that and families. But what about if you're single? Do you need life insurance? If you're not, you don't have anyone to leave it to. Do you need life insurance for those who are single?
Okay. So does a single person, I guess there are a couple of things in that question. One is, do you need life insurance is really a financial question. And though I've got my own opinions on it, I'm not a financial advisor. I'm a lawyer. But the answer, what I can tell you why most people, in my experience, buy life insurance. They buy life insurance to replace income that the family would lose if they die, or they buy life insurance maybe to provide an inheritance or liquidity for an estate, or to for a business, so that a business can hire someone to replace them if they're the key person that's running that business. It's not a bad idea to have life insurance on that person, so you can go ahead and hire someone to run the business, and then the family still keeps the economic value. So life insurance has there are many reasons why you might want to have life insurance. But to the question of does a single person, let's say a single person without any children, do they need to do any estate planning? And I would say, yes, they do. They need to do estate planning because estate planning includes not just what happens when you die, and they may have thoughts about what they want in terms of who is going to be in charge. It may be even more important because let's say they're not married, they're single, and they want some distant family member who they never got along with to come in and bar their friends from their funeral? I mean, do that, or from seeing them in the hospital? Probably not. Okay. So it's important for single people. I say that once you turn to the age of 18, so someone goes away to college or they're leaving the house, they're at the age of 18, they should get themselves a will, a general durable power of attorney to manage their financial affairs. They may not have a lot of financial affairs, but whatever they do have, their student loans or whatever, and a healthcare power, particularly a healthcare power, to deal with what if they get sick? What do they want done or not done? They're 18, they're an adult. As their parent, you don't necessarily have the legal right to determine what's going to happen to them, how they will be cared for once they become an adult. And so if you want them to, I know I'm jumping around a bit, but this question.
Mr. Carty, can I just interrupt you 1 second? And
Sure.
we probably have enough questions in the chat right now to take us through all of the time that we have. So before we go back to another question, do you want to give us are there more points in your presentation that we can hit really quick and then come back to the questions just to make sure that we get all of the information you wanted to give us and then come back to the Q&A?
The answer is yes, I'll do both.
Okay. Okay.
To the best of my ability, I'll try.
Okay. Okay.
So what I want to do is, yes, let me move on and give everyone some of the basic tools. And I think that's what I hear the chair saying that it would be helpful. Let me give you those basic tools.
Now, I think answering the Q&A is important too. I just want to balance it in because we've got about 15 minutes left.
Okay.
Okay.
Wow. Okay. I will go through as best I can here.
Okay.
So let me say, we talked about a will. We talked about a general durable power of attorney. I just briefly mentioned it. That is a document where you appoint someone to manage your financial affairs if you become disabled. Okay. So that's while you're alive. That's not about when you die. When you die, that general durable power of attorney ends. Okay. It is a document for managing your affairs while you're alive. It is a very powerful document. A lot of people focus on the will and they don't do the general durable power of attorney. Big mistake. It carries a lot of weight. Why? I told you about people fighting over the elder, who's going to be in control of them. If you have a general durable power of attorney, you can appoint someone to manage your financial affairs. And you don't have people fighting over, am I going to get control of mom's or dad's bank account or my brother and sister? And so if you can avoid that document can help you do that many times. Healthcare power of attorney. Healthcare power of attorney And I want to go through a few terms that are often confusingly used, okay? Healthcare power of attorney is where you appoint someone with authority to make healthcare decisions if you're unable to speak for yourself, okay? It's also called a healthcare proxy. Those are the same thing. Advance directive or living will, they're the same thing. That's where you give written instructions on what you want done or not done while, with respect to your healthcare, while you're still alive. This obviously deals with while you're alive. We suggest you combine the two in a document. And then we suggest you do something different or you seriously consider doing this differently than the way most of these documents are done. Now on my screen right now, I can see the members of the sorority, and I say to you, I'm in front of, I can't see everyone else, but I'm assuming I'm in front of a number of Black women. And this is extremely important, especially, it's important to all folk, but it's important to Black women in particular. I do not have to tell you about the tremendous disparities in maternal mortality and healthcare disparities when it comes to Black women getting healthcare. Okay, there are well-documented, disparities there. So if you're going to protect yourselves and your family, I suggest you consider empowering someone who you pick, who you've talked to about what you want, who understands your values. You give them the legal authority to make decisions. You put in the document some instructions, so you're giving them some guidance, but you also give them the legal authority to override those written instructions. And you may say, why would you do that? Well, the reason why these documents tend to be done in the reverse is they're focused solely on the risk of the rogue agent, the healthcare agent who doesn't listen, who won't follow your wishes, so they can legally be held to your wishes. And I submit to you that another risk, which people are not taking into account, is the risk of institutional racism in the delivery of healthcare, sexism in the delivery of healthcare, ageism in the delivery of healthcare. All of those issues create risks to your family members and to yourself. And so you would prefer, I would think, to have a situation where, and I actually unfortunately there are situations that have occurred where a hospital, they have lawyers on staff, okay, holds up a document and says, Miss So-and-so, I understand you feel strongly about this, about your mother's care, but your mother is our patient. She signed this document, and this document says she wants us to withdraw life support. And so come 12 o'clock tomorrow noon, that's what we're going to do. And if her sister can't get here in time, or cousin so-and-so can't get here, or whoever, sorry, but that's what's going to happen. We're following our patient's wishes, and we have the legal authority because our patient put this in the document. That's not what the person intended. Many times, okay? Many times what you will find is you would like to have a situation where your family member could say, thank you, doctor, thank you, hospital, very much, but I'd like to get a second opinion. So I have the authority under this document to override what it says, to transfer my mother to another hospital and to Dr. So-and-so, and then, thank you for the care you've given me, but let's make those arrangements now. And if the hospital does not want to cooperate, you can go to a judge and seek an emergency order. And the hospital knows that. So what does that mean? What it means is your family members will be treated with more respect. Why? Because they'll have more power. You are leveling the legal power equation there. Now, I'm not saying that that's going to happen to you or your families, but if you have an attorney who's going to be advising you about how do you best protect yourself and your family, you cannot ignore that risk. You must be alerted to it, and then you must make the decision about, is this risk big enough that I should change the way I do my documents? Or maybe I want to restrict the person. But I got to tell you, there are documents out there that said under no circumstances do I want experimental treatment. Well, COVID, All the treatments, I think, are still experimental for COVID. Did you mean you didn't want monoclonal antibodies or whatever else they could give you that could help bring you back? I don't think that's what you meant when you wrote that document. But if we're in a busy, overwhelmed hospital and they're making decisions on who gets care and who doesn't, isn't it easier to hide behind that document and say, well, she didn't want experimental treatment? So all I'm saying, the best lawyers in the world, the best client in the world together cannot write down a document that will capture everything perfectly. And that's why you want to seriously consider empowering someone to be your advocate and giving them that discretion. Don't leave them adrift. Give them some guidelines, but give them that legal power. So I just talked about the healthcare power of attorney and about a suggested approach. Let me also talk about your probate estate and your non-probate estate. And I think I'm almost out of time, but
why don't we go like, can you cover that in like 5 minutes, and then
sure.
and then we can use the rest of the time to go back to Q&A.
So yes.
Okay. And then we'll have about 10 minutes for Q&A after that. Okay.
So next 5 minutes, what I'm going to do is, let me just throw a few other things really quick for you. Your non-probate estate and your probate estate, they must be coordinated. What is your probate estate? Your probate estate is what's governed by your will. Your non-probate estate is not governed by your will. So people mention life insurance. That's governed by contract law. The beneficiary of that life insurance policy is going to get paid that money regardless of what your will says. So if you have 3 kids and you want to treat them equally, and your will says treat my 3 kids equally, but your life insurance, the beneficiary is just the oldest gets the life insurance plus 1/3 of your probate estate. Okay. What else is in your non-probate estate? Those things that you own jointly with others with a right of survivorship. So let's say a deed on the house. If you're joint with your second child on the house, they're going to get that house plus 1/3 of your probate estate. Now, the other child who's not on the life insurance, who's not on the house, what do they get? They get 1/3 of your probate estate. What is that? Let's say all you have, probate estate is what you own in your own name. No beneficiary designation, no joint ownership. Okay. They're going to get, let's say you have a bank account for $6,000. They're going to get 1/3 of that, $2,000. That's it. They were not treated equally. So that illustrates you must coordinate the two, the non-probate, the probate estate. With respect to, you will hear people talk about revocable trust, living trust, avoid probate. So a revocable living trust is simply a trust that you set up while you're alive. It's not in your will. It's now. You set it up while you're alive. You can manage the property in that trust just as you normally do while you're alive. It does not protect those assets from the cost of long-term care. It really does. It doesn't protect them from creditors because you can reach those assets. Why would you want to do a revocable or living trust? Well, there are many reasons, but if you have a small business, not a bad idea to avoid that business going through the probate process, put ownership in that revocable trust. If you own real estate that is outside the state of New Jersey, you want to have a revocable trust, that real estate owned by the revocable trust. Otherwise, your family has to go through probate process in New Jersey and then go through the probate process in that other state for that piece of real estate. But remember, if it's in the trust, when you die, then the owner on the deed did not die, so there's no need for probate in that other state. We don't have to go to North Carolina because the property in North Carolina was owned by the trust. Long-term care planning. This is a cost which cannot be ignored. So let me just say, give you the likelihood of occurrence and the magnitude of it. The long-term care can cost, let's say nursing home care, can cost anywhere from $10,000 to $20,000 a month. The average stay in a nursing home now is around 4 years. So at $10,000 a month, that's close to $500,000 for 4 years. At 20, it's double that, $1 million. That's a huge risk. What's the likelihood of that risk occurring? If you're over 65, about half, a little more than half the people over 65 will probably have a need for institutional level care sometime during their life. We're living longer, but with more disabilities. So if the likelihood of occurrence is close to 50% and the magnitude of occurrence is close to $1 million, you cannot ignore that risk and say you've planned your estate to pass to the next generation in inheritance. So how do you deal with that risk? Possibly through long-term care insurance. If your employer offers it, you want to think about making sure you have it. It can be very expensive the older you get to get it. But also there's something called Medicaid planning or asset protection planning, which many times will use irrevocable trust and other techniques to shelter assets from being used for the cost of care. So let me just illustrate for you very quickly a way that this may come into play. So mom or dad, the elder gets sick. We need to pay for a nursing home. A lot of people think Medicare will pay. Medicare is not designed for long-term care. It will only pay for probably the first 20 days of a nursing home stay at 100%, the next 80 days at 80%. But Medicare will stop paying once you stop making progress. Medicare does not pay to keep you well. It pays to get you well. Then it cuts out. So you're not guaranteed the full 100 days. So many times the adult children will come to an attorney and say, mom or dad had a hospital event, went into the nursing home, they did rehab, Medicare was paying, everything was great. Now they tell us they're not going to pay anymore. They give us this paper that says we have a right to appeal. What are we going to do? Well, it tells us we got to pay $10,000, $20,000 a month. We can't afford that. They say we got to sell mom or dad's assets. They have too much money from Medicaid to pay. Medicaid says an individual can't have more than $2,000 of countable assets if they're going to qualify, or maybe more than a small amount of income. Income is usually not the problem for most people. Pension, Social Security, we can use a qualified income trust to get over past the income qualification for Medicaid. The big issue usually is assets. So how do we qualify for assets? A lot of people will say, oh my gosh, mom or dad, why don't we just give the inheritance to the kids now? I'll just sign the house over to the kids. That'll save it. No, unfortunately it won't. Medicaid has a 5-year look back. So if you can make a gift within 5 years applying for Medicaid, Medicaid's going to look back and penalize you with an ineligibility penalty based on the size of the gift. What does that mean? Simply means Medicaid's going to not pay for care for a certain amount of time, depending on how much money you gave away. So this type of planning you want to do at least 5 years before you need it. You want planning horizon of 5 years plus when we're talking long-term care. So I know I just said that may be available to help with the cost of long-term care. You should explore that as well. And then business succession planning, I will just quickly touch on that. Think of making sure from a legal point of view, I mean, there are operational things you have to have in place, but make sure that the legal documents are in place for the business. If it's an LLC, that it has an operating agreement, or if it's a corporation, that there are bylaws and that there are officers that have been elected, people who have authority to access the bank account if you're not there and you can't do that, to make payroll. You want to make sure that there's a buy-sell agreement so that if, let's say, you're in business with other people, that they can't just sell their shares of the corporation or of the LLC to your worst enemy, okay? You don't want that. If someone decides they're going to retire, you want to have some way in that buy-sell where we have a fair process for evaluating, valuing what their share of the business is worth and how they'll be bought out. If they have to be bought out all at once, that could kill the business because cash flow is the lifeblood of a business. So as I said before, key life insurance, key person life insurance, you want to have that if there's a key person in the business, okay? If I die and my estate has the ability to hire someone with my skills, they may not do it exactly the same way I do it, but the business may be worth something. Whereas if otherwise, it may not. Where they're going to get the money to hire that person? Well, maybe life insurance on the life of that key person in the business. So in conclusion, what should you do with your estate planning? At least get those 3 essential documents in place that we talked about: the will, healthcare power of attorney, general durable power of attorney. Consider if you need the higher level of planning with a revocable or living trust. And don't forget about long-term care planning. You've got to make sure you cover that risk because it is so big and so many people will have that need to pay that expense. And remember the things we talked to you about in terms of inheritance, New Jersey inheritance tax. New Jersey does not have an estate tax right now, so you don't have to worry about that. The federal estate tax, you don't run into that unless you have close to around $13 million. So if you have that problem, that's a good problem to have. And then you will need to do some tax planning, but most people aren't going to run into that. So you want to do that, and you want to do some business succession planning. But that's really looking at doing estate planning from that perspective, including those elements, and looking at it as a tool of liberation, which empowers you to govern your family for yourself as opposed to leaving it to others. And that will allow you to do the economic development that is your mission. And I thank you very much for giving me the time that you have tonight. Thank you.
Are you good to stay on for about 10, 15 minutes to take some questions?
Sure.
Okay. And then we'll zip through the raffle and the resource guide. But I think you've given some good information that made people think about some things they hadn't thought about, and our questions are really loaded up in the chat. So Carolyn, you want to take over?
Okay, so I'm going to try to give you a quick hit, Mr. Cardy. How
Okay.
often
You got 10 million questions to
I got,
answer
but I'm
in
going to do this
15
one.
minutes.
This is a quick one, right? So how
Okay.
often should you review your will?
From anytime there's a major life event, birth of a child, marriage, divorce, any change in financial or health situation, you want to review your will, other in your estate planning documents. Otherwise, generally at least 5 years maximum, but 3 to 5 years, you want to take a look back at it.
Okay, here's another one. What drives the cost of setting up a trust?
What drives the cost is really the complexity. It depends on what the needs are. And that's why I always advise people first understand what your goals are, what the needs are, then figure out what is the tool, the particular tool. So don't, some people say, oh, you must do this, living. Use the tool appropriate for the problem that it's trying to solve. That match the tool to the problem. That's the way you really save on the cost of all the estate planning.
Okay, excellent. What advice do you have for leaving assets to multiple relatives, a vacation home to more than one person?
I would say if you leave property to multiple people, consider the use of a trust. And here's why. There's been a tremendous amount of Black land lost throughout the South. And it's lost many times because it's in fractional shares. They have people in Texas, they call them landmen or whatever. They have people that will, their whole business model is to go find the weakest member of the weakest, financially weakest member of the family, buy the rights to their share, then go to court, seek partition of the property, and there will be an auction because many times the family members don't have the cash to buy out this person. So if you have a trustee, if you centralize control, so we're talking about family governance. If you centralize control where there's a trustee who can decide and who can muster the resources of the trust, maybe we'll sell off those acres so we can hire the lawyers that we need to fight off these predatory people who are trying to steal the land. It takes group action. And in order to have group action, you need the group to have some governance. That's why the fractional ownership, you make yourself easy picking for outsiders. That's just in general.
That's good. Excellent. All right. What are good strategies for bringing highly resistant elderly parents to plan their estate and will?
That's a good one. You may have to do it in small bites, that you don't talk about everything with them at once. You have conversations, and two things about the conversation. don't do the conversation in terms of what you're going to have them do or what they should do. Because what they want is they want a sense of control and agency in what's going to happen next. So show them that that's what you're trying to do. You're trying to help them. You're not there to tell them, Mom, Dad, you don't know what you're doing. This is what you need to do. I've got all this knowledge. I'm going to tell you how it is. Mom, Dad got a lot of wisdom, okay? And there's a difference between wisdom and just knowledge, okay? You need both, okay? So really respect the elders' wisdom. Try to talk to them in small conversations about different issues and show them how this is how you can help empower them to be in control of this process, and that you're working for them to help them develop a process and so it'll look like what they want. And most elders, once you get to that point, they will be way more receptive to you than you come in there and try to tell them that, well, you know something they don't, and they should do something your way. That usually doesn't work very well.
Thank you for that. That's great. What is the best place to leave assets for an adult child who is handicapped to a family member that is a niece or a cousin, will or trust?
You're going to need a special needs trust. And the special needs trust could be set up. There are different ways to do it. There could be in your will. You could set up a special needs trust for that person, that disabled person, or you could, there could be one set up by the family now for them. And your will could leave it to that trust. So it really depends on the situation. But if no one's done anything, and that's not uncommon, and you're saying, look, I'm going to do something right now myself, I want to help them, then if you're going to leave it to a special needs trust in your will, or, depending on if you're using a more complicated revocable trust, it'll be a special needs trust in the revocable trust.
Thank you. I just want to pause and give a time check. Do we have time for another question, Madam Chair?
Yes, yeah, I'm gonna say that we will go, it's 8:33 now. Let's go to, let's take 2 questions.
Okay, all right.
Okay.
What amount of money is exempted from New Jersey New Jersey inheritance before the state freezes assets?
We say what amount of an inheritance is exempt? The question, I think I don't know if you're talking about from taxes or qualifying for Medicaid, or let me just answer it this way. I mean, from inheritance tax, like I said, for brothers and sisters, there's a threshold level. And I think off the top of my head, I don't want to tell you wrong, but I think it's something like around 20 grand or something like that. But for Medicaid, if you're talking an individual, no more than $2,000 of countable assets. And there are countable and non-countable assets, but I don't think we have time to get into that right now. So I guess that's the best I can answer that question at this point.
Okay. And I think that wraps it up, because the last question the person said was answered. And the other question was, when can you come back?
Oh.
They want to know, when can you come back? That was the other question. So I think we're pretty good with the questions. See, that we're just loving you, Mr. McCarthy. Just love you.
I appreciate you inviting me. It's something that it's so needed, and I applaud you for all that you guys are doing for the community and economic development. And I want to say one thing, if I can, if you indulge me. I've seen Delta gyms and the impact they've had on young ladies, and it is tremendous. And I want to applaud you for the Delta gyms program. And I do know a young lady who is now a medical doctor, very much inspired by the Delta gyms program. So I want to thank you for that.
Thank you. Thank you so much. We have a few more things we're going to do, but in case you need to run, I do just want to say thank you to you. I mean, we received a great amount of information, and certainly information in some areas we may not have thought about. I got to tell you, when you were talking about putting assets in trust for your minor children, I was like, whew, thank God I made it through that, because I did not do that, didn't even know I was supposed to have done that. So real happy that I made it through that point without dealing with that. But I mean, and I think for all of us, what you did was you really did help us to connect the dots between planning and increasing generational wealth. And that's what this is all about. It's not just like you said, checking the boxes and having a will. It's how do I do this so that I'm preserving what I have and transferring it. And I really, really, really appreciate that. The entire chapter of Central Jersey Alumni Chapter, my committee, our president, we all thank you for the information that you gave us. And I'll do this now while you're here so people can hear it. I'm going to challenge everyone who was a participant on this call within the next 30 days to do at least one thing to move you forward in planning for how you're going to preserve and transfer your assets. If you already have a will, then think about whether a trust is needed. If you don't have a will, get a will in the next 30 days, okay? Just think about what you can do next. If you're a business owner and you haven't thought about the continuance of your business, then make that the one thing you commit to do in these next 30 days. So again, I want to thank you so much. And as in the chat, there was a question, when can you come back? We're going to commit to getting him back to give us some, because we know there's so much more information he has that he didn't get out to us, and more questions that we know people will have. So thank you, thank you, thank you. And you're certainly willing to hang on for the end of the program, but I just wanted to make sure we acknowledge our appreciation for you right now.
Oh, well, thank you very much. I appreciate that.
Thank you. Thank you. Okay, Ellen, do you want to move into the raffle?
Yes, thank you again so much, Mr. Cardy. Yes, it was absolutely wonderful. We're so grateful to have that wealth of information. Right now, we're going to spin the wheel 4 times for our giveaways. We have 2 very useful gifts. You can see them on the screen and are available on Amazon. The first one is Checklist for My Family, a guide to my history, financial plans, and final wishes. And the second one is my estate planner, essential information for my family. But before we spin, we just ask you to listen carefully, because we do need for you to put your name, address, and telephone number by email to cjaeconomicdevelopment@gmail.com. We are ready to spin the wheel. Tanya Gibson, congratulations. Please make sure that you name, address, and phone number in the chat. Our next spin. Oh, Julia Amica Porterfield, congratulations. Our next spin. Sonia Lavette, congratulations. And our last spin. Therese Clark, congratulations to all of you. Please make sure that you leave that information at our email at CJA Economic Development. Thank you very much.
Can someone in the committee, or can those 3 winners please
Four.
put your hand up. So, or 4 winners, my apologies. Put your hands up. We want to make sure, because as we said in the beginning, you have to be here to win.
Someone did. I saw one. There goes
Okay.
Therese Clark.
I see Therese Clark, Sonia Levette,
Mhm.
Sonia
Mhm.
Levette is here. I see
She's
her in the
here.
chat.
Mhm.
thank you, Sonia.
Tanya Gibson is here. I don't think Miss America Porterfield is here. And in that instance, we need to spin the wheel again.
Okay.
Okay.
Crystal Cole.
Crystal Cole.
Crystal Cole is here.
Okay.
Okay, great. Congratulations to all our winners.
Yes,
Your
congratulations.
prizes will be sent directly to you via Amazon. But we do need your email addresses to do that.
Names and addresses.
Right, email address,
Na-
name, and your mailing
Addresses and
address. Sorry.
yes, right.
Yes.
Okay.
Thank
right.
you.
Mhm. Mhm.
These are just some online resources that we wanted to share with you. We will put this in the chat as well. The links will be in the chat to these documents. We just wanted to share some of these things with you. The Institute for Policy Studies, The Boldest Step to Close the Racial Wealth Divide in Generations, the Legacy Assurance Plan, and also Roth Elder Law, and National Care Planning Council. So this information will be available in the chat as well.
All right, everybody. You love the program. By the questions, the excitement, I can feel the excitement. So make sure you take the survey. So the link is going to be in the chat. There's also the QR code. So make sure you click on that. But tell us what your thoughts are. Should we do it again? Say, by the judgment of all the questions, I say we do it again, right? Mr. Carty was excellent, but sure does let us know by taking the survey. Can we keep putting the link in the chat so everybody gets that?
Yeah.
All right. We love your feedback. Everybody get it? All right. I think they got it.
Okay.
All right.
Yep, we can move on.
So you love that program, right? And now you're saying, hey, I want more. I want to come to more CJA events. Well, excellent. We got you. We have on October 26th, we have Why We Vote Town Hall in Middlesex County at the YMCA Piscataway, beautiful facility. So come out and join us. Also, we have one at the Somerset in Sampson G. Smith Middle School. So come on out. Tell us why. Come on out to Town Hall, November 30th, Black Women in County Government. Come on out. December 1st, World AIDS Day. Now, this is the big one. This is where you really need to come out and show your love. December 2nd is the prayer breakfast. That is an excellent fundraiser. I know you want to be there. I can feel it. I can sense the excitement. So come on out. It's at the Pines Manor, December 2nd, prayer breakfast. And if you want more information about all the great things we do, because you know we do a lot of great events, visit www.cjadeltas.org. Okay? And thanks so much for being with us. And thank you to Mr. Attorney Carty. What an excellent information.
In front of you on the screen now, you see the members of the CJA Economic Development Committee. And can we just clap it up for them along with Mr. Carty for this excellent programming? there was, this was truly a team effort where many of us had to move outside of our comfort zones to produce this wonderful and powerful event. And I am so appreciative. And I know Alika Muhammad, my co-chair, she's been on mute the entire time because she's got some work issues going on, but I know I'm speaking for her as well, is that we are so appreciative of the committee and so appreciative of Mr. Cardy for pulling this entire thing off tonight. I just want to clap it up for them because I really, really appreciate it. In closing, I just want to remind you to go to the CJA website to follow us for our future programming and to register for those events. And we're going to work on trying to get Mr. Cardy back to come back again for us. And with that, I say good night and thank you for coming, everyone.